Sound check, sound check. Sound check. Can you hear me? If you can hear me, please respond.
can
Unmute
hear you.
yourself and respond if you can hear me.
I can hear you.
Okay. Registrar, can you hear me?
Okay.
Joshua Folabi, can you hear me?
Yes, I can hear you. I can hear you.
Yes,
Okay,
I'm
thank
hearing.
you. Then the next person I see, Soji Toki. Can you hear me? Are you there?
Yes.
Okay. Mr. Soji, please, can you release your camera?
Hello, this is Soji Toki.
Yeah, Mr. Soji Toki, please, can you release your
Yes,
camera?
yes, I'm the counsel for the appellant.
Okay, your camera is small. Can you turn on your camera?
Can do. At least you can hear my voice. I'm here already, so
Loud and clear.
that makes it easier. So my colleague is also here. Joshua Folabi is my colleague.
Okay. See how can you hear me?
Hello. So let me mute my microphone now.
Okay. I believe all sound check are in order. So are we all set to go?
Yes, we are
Please
set.
confirm your readiness.
We are ready. We are ready to go.
Okay. So we'll kick off in about 3 minutes.
Whoever is not speaking is required to mute. For all participants, if you are not speaking, kindly mute. But remember to put on your speaker if you want to speak. Please remember to put on your speaker if you want to speak. Remember to unmute yourself.
No, I think she has bread.
Tell her to leave that endorsement. That endorsement.
Suleiman.
Good afternoon, gentlemen. You're welcome to the
Good afternoon, sir.
some hitches. So we are good to go now. So please,
As the court pleases. Judgment. Appeal number CA/A/122/2019 between Abu Al Kazim Limited and another and First Bank of Nigeria PLC.
any of the parties around?
All parties are absent.
The appellant
Yeah.
is represented. He has joined the Zoom by the second appellant.
Appellants represented.
The appellants are represented by the second appellant who has joined the Zoom, sir.
Right. Appearances.
With my Lord's kind permission, my name is Soji Toki. My humble appearance, my Lord, is for the appellants. Soji Toki, my Lord. Soji is S-O-J-I, and the surname is T-O-K-I. With me, sir, is my learned friend, Mr. Joshua Afolabi. For the appellants, my Lord.
Yes.
We have also sent our name through the chat platform.
Okay.
Oh, my lord. The respondent is not here with us. Yes, my lord, he was served yesterday by a phone call.
Through their counsel.
Yes, my lord.
Is that my lord? It's just, if you unmute himself, let me just, I don't know.
Please unmute. Come on, unmute this. All right. Is there anybody for the respondent?
Oh, my lord.
My lord, I think he's running to Annie. He's speaking, but you can't hear him.
There were some two counsel.
Yes.
Yes, my lord.
I've already told them finally, and they are all fine with them.
Sound is very poor.
The respondent through counsel will go to deliver this judgment.
As the court pleases.
This appeal was heard
This appeal
by
was
a panel comprising
a panel
my humble self, my Lord B.M. JCA, and my brother Mohammed Mustafa JCA. I did the lead judgment. In this judgment, I wrote the lead, which I am going to deliver, and my brothers and my parents, because it's a unanimous decision of the court. So there is a judgment. This is an appeal against the decision of the High Court of the Federal Capital Territory, Abuja, the suit number CV 305 2016, delivered on the 17th day of January 2019. Lando Tengo J was the judge of the lower court. In that judgment, the claims of the respondent, who were the plaintiffs, who were the plaintiffs for payment of loans secured by the appellant, before the lower court was granted meritoriously. The appellant now dissatisfied with the state judgment appealed against it, with a notice of appeal filed on the 11th of February 2019. The appeal had 6 grounds. Record of appeal was transmitted to this court on the 15th day of February 2019. Then the appellant's brief of argument was filed on 29th March 2019. Respondent's brief also was filed on that 29th of April 2019. At the hearing of the appeal, Senate counsel the appellant adopted the appellant's brief argument and urged the court to set aside the judgment to the lower court. On his part, Senate counsel for the respondent adopted the respondent's brief of argument and urged the court to refuse to set aside the judgment to the lower court, rather advancing in the interest of justice. The appellant's brief 3 issues of determination were distilled from 4 grounds of appeal, thereby abandoning 2 grounds, as no issue was distilled therefrom. So the issues which were distilled listed as follows. Some of 7 from the lower court to the defendant the respondent a sum of 7.7 million is sustainable against the second appellant who accepted it failed not to be set aside. Lastly, whether the judgment of the lower court by the judgment of the lower court, the second appellant is document of and yeah, on the other hand, from the 4 grounds, namely, very well, whether it is completely the respondent is occasion in miscarriage of justice against the appellant, as to whether the judgment of the lower court, that the appellant is jointly liable for the indebtedness in the case, and to jointly pay the respondent is claim is justifiable against second appellant. Thirdly, whether there is evidence on the court supporting the judgment of the lower court and or by which the lower court situated the same address with the respondent and to deposit them with the respondent. Lastly, whether the grounds of appeal are argued by the appellant as to warrant the dismissal of this appeal, and these were distilled from grounds 1, 3, 4, and 5. The facts of this case are found in the record before it. Not too complex. There are a case of a facility which was by the appellant from the respondent, and then it was 6 million from them with the interest that gone to what it is at the present moment, which is 7.7 million, 790 pounds that the suit is that by a special endorsed with filed on that day. And then it was looked into by the lower court, and the lower court now came up with a decision, a well-considered judgment, in his judgment. And it is there on this that the defendant accepted the offer of the 3 when the second defendant signed the 3 on behalf of the first defendant. Therefore, defendants are bound by all the terms and conditions. And then the of the respondent, who was the plaintiff at the lower court, was and some other release were rejected. So that is the preliminaries of what happened. So on their part, appellants admitted that they defaulted in payment of the but then to the dead. And the hearing, because we're supposed to look into whether the order of the lower court ordering the appellants to pay the sum is supported by evidence. And when that was said, if it was not, that the judgment should be set aside. So arguments were taken on this because of the Zoom facilities that what is that at this issue. Argument what was the on the ground by Exhibit A11, that's A11, which is displayed at page 36 of the record of appeal. This exhibit, which was a letter of government to the respondent, reproduced here. That letter was demanding for the payment of the outstanding money, and there, the appellant then now responded on that Exhibit A11 that they are ready to pay off the loan and that they are making arrangements. And the last paragraph of that careful consultations and evaluate relations and or loan by enter there. This letter of the appellant is clearly explicit as to the fact that the appellants are admitted on record that they took the loan in issue and that they have started the repayment of the same loan. They made a commitment in Exhibit A11 that they will raise money through family and friends and pay off by February 2015, and this remained unpaid, and the evidence before the Najibu and Ajayi, the Supreme Court said that admitted facts no longer in issue. The plans as in Exhibit A11 of the indebtedness issue to be contested. The lower court was there to order the appellant to conclusion that issue one resolved and is resolved thank you for bearing with the situation. We have resolved the first issue, and those key lines are the fact that having looked at the issue one, from what we have said on that issue one, thank you for bearing with doing the responding the lower court cannot be faulted from the order given in the case. It is in this respect that we say we should not against the appellant. Now, in issue two is whether the judgment of the lower court to the effect that the appellant should jointly pay the respondent the amount in question sustainable against the second appellant, who acted as an agent of the disclosed principal, same or to be set aside. Then I cancel for the appellant also the arguments. These arguments are also captured here, and we say that the second appellant in this case referred to himself as the agent of the disclosed principal, which invariably referred to the first respondent. We say we saw this as interesting. The second appellant is from the record before the court, not an agent but the alter ego of and a guarantor to the first appellant in the transaction. In the case of MMA and Inc. and another, it was MMA, or citations supplied here. We say the company is only a juristic person. It can act through an alter ego, either its agents or servants. Evidence of EW1 is given. Well, evidence is that when the legal status of a company is looked at, it is human beings that act on its behalf. And these have been well looked into as another authorities. You can see Oyebanji and the states. And also we've seen and cited some other authorities which in this segment. And we say that the appellant here, the second appellant particularly, is not just an agent. He is the alter ego and a guarantor of the loan, which has been exhibited here from Exhibit 8 and A6. We've seen the participation principally as a guarantor. All the forms were signed by him. The request letters, replies, everything were carried out by him. And so from Exhibits A4 and A8, this man cannot just claim to be a mere agent. He is the whole substance of the negotiation, and the indebtedness was part of what he has invested in from the beginning. So he cannot at this point now, say that he's an agent, he knows nothing about it. He cannot be. He is deeply involved. He is the one. And being a guarantor, if there is a failure of payment, it is his responsibility to ensure that payment is effected. So having looked critically at this issue 2, we now come to the conclusion also that issue 2 is resolved against the appellants. Then the final issue, which we captured as said by the appellants, is issue 3. This is whether the judgment of the lower court is saying that the holding of the title of the document, which was used as collateral for the loan, was held as a trustee to the respondent, and that he should deposit same with the respondent in this case. The Learned Counsel for the appellant submitted that there is nothing before the lower court to support the finding that the second appellant is holding the title document as a trustee. There is no evidence, he said, that the documents of title to the property are with the second appellant, and that the court must act on credible evidence before it, and on he argued. We've captured this argument, looked into it critically, and also looked at the argument of the respondents. The learned trial judge, we say, relied on the authority of Ibekwe and Nwosu and they refer to second respondent as constructive trustee. A person becomes a constructive trustee, or which may be inferred by the court due to the evidence that a party's conduct is unconscionable, or that a person cannot be a trustee if he is ill-informed of the facts alleged to the effect of his conscience, to affect his conscience. There must also be recognizable trust property, except where a constructive trust is imposed on a party who dishonestly support another in case of breach of trust. For looking at the contents of Exhibit A4, as a letter of consent to mortgage, the second appellant here clearly admitted and even signed a consent letter where he admitted to being the owner and also agreed to use the property situated at B15, Area A Extension, Nyanya, Abuja. He went further to state that the said property belongs to him and is given as a security for the facilities, the loan that was going to be taken, granted to his company, Abu Al Qasim Limited, by the First Bank PLC. Even though it was negligence of the respondent to disburse loan without collecting the collateral documents, Exhibit A4 has clearly shown the intention of the second appellant, being the managing director of the first appellant, to use his property as a mortgage for the facilitation of the loan amount. The appellants cannot therefore come back and try to benefit from their own wrong by saying, I'm frying at the party who said is bound by a condition and that the latter sought to take advantage of his own breach can never be allowed by the law. There was an agreement between both parties to use the same property as mortgage, and the principle of pars sunt servanda must be adhered to. The second appellant should therefore submit the title document. The respondent. Again, Exhibit A4 shows the intention of second appellant to mortgage his property to facilitate the loan. The law is well settled that the intention of the parties to an agreement or contract is always to be gathered from the document or documentation of contract, where the contract is written, as it in this case. The duty of a court when it comes to the terms of a contract is not to determine or to rewrite the terms for the parties, but to construe the words used where there is confusion. And here is so clean, so clear that there is no controversy about the fact that this second appellant used that same house as collateral for the loan that have not yet been paid back. So he cannot wash his hand of it, and he must get stuck to it because he deliberately went into this agreement without anybody forcing him. In the light of the above, issue 3, therefore, is resolved also against the appellant. He, I must say, who goes borrowing from the bank must be honorable and responsible enough to pay back what he borrows. Albeit when you come to realization that the money in the bank belongs to some other people who are also keeping the bank the trust of their money. And so when somebody borrows from such people's money, he must be honorable enough to pay back this loan so that the banking system will not collapse and so that nobody's right also is sabotaged. From the foregoing, therefore, I come to the conclusion that this appeal is bereft of merits. The appeal is hereby dismissed. The parties are to bear their respective costs.
As the court
says, yes, this decision is unanimous. All of us are in agreement with this judgment.
My Lord, sir. My name is Soji Toki for the appellants. I must sincerely, sir, and genuinely from my heart, commend my Lord's industry in this judgment, sir. We have.
Thank you. Thank you.
Very great. Hello, sir. Am I on, sir?
Yes,
am I on, sir? So, my
Lord,
thank you, my Lord. As I said, we, on our part, we are bound by this judgment. It is very sound, it is very genuine, and very germane, and it actually exposes the principle of the law. But my Lord also knows that, sir, we do respect that we act for a client. So we convey the judgment to him to know the next thing to do. But from our heart, sir, we thank your Lordship for this industry. And I must also commend my learned friend on the other side for his gentleman approach to this case. My Lord, sincerely, sir, thank you very much, sir.
Thank you all, and we thank our technical team and all those concerned for their efforts in making this delivery a reality. So thank you, and the records are available in the registry for the parties to collect. We sincerely appreciate you for all that you are putting. So thank you. Having come to the end of the proceedings, the court will now rise.
Hello, beloved registrar. Hello, registrar.
Hello.
Hello, registrar.